You're listening to the Valley Current.
Hi.
Hey, Raphael, how are you?
How are you?
I'm good. Yourself?
Fine, thank you.
Gosh, there's so much going on in the world. We could talk about so many things, but the thing that's top of mind for me is this case that Twitter filed against Elon Musk's holding subsidiary. It's not against him individually, it's against the entity that he created to merge in or purchase for cash all of the shares of Twitter to essentially control a public company that he said he was going to take private with the view of doing a bunch of stuff that he didn't think as a public company Twitter could do. So I'm just amazed that he's actually decided to announce that he terminated the deal, given all the enthusiasm that he seemed to express about the deal, and the fact that the agreement is what everyone seems to be saying is a seller-friendly agreement. And so it's a long agreement. I know you and I have struggled to kind of get through it.
Well, first of all, he is a named defendant personally.
Oh, is he? Did I miss that? Because I thought it was just an individual. Is he actually named in the suit?
He's actually Elon R. Musk, X Holdings, and X1 and 2.
Okay, so see, I thought I misread the caption. I thought it was just his entity, but they actually sued him on some sort of personal guarantee or personal liability.
I think they did it because he's the actual person in interest. Just a minute. Let's see.
The signatory to the agreement's the entity, and he signed, I think, a personal guarantee for some of the financing, but he didn't sign as the individual purchaser. He's obviously the person behind the entity. I didn't see any alter ego type allegations in the complaint.
Well, Musk signed the merger agreement on behalf of both parent and acquisition sub and agreed to be a party to the agreement in his individual capacity as equity investor with respect to several specified provisions.
Oh, okay. So he's in, but he's not probably in for all of the thrust of this, right?
Perhaps, although they could pierce a corporate veil there. I mean, there's not a lot going on with these companies other than him.
Right.
I think the whole question, if he had come to me and said, should I do this deal? I would say, what can you do for Twitter that they're not already doing for themselves?
Well, he would say, take them private, change a bunch of stuff. He did say he was going to reduce the amount of spam or bots or.
Precisely.
Right.
His main thing was, I'm going to be the hero and kill all the bots.
Right.
So that was his focus when he went into the deal. He has no justification for now bringing his present legal position long after the deal.
Right.
In other words, if that was his claim, he should have either looked into it or he's now got what he planned.
Yeah, they announced very clearly that he waived the due diligence on the bot issue, which I think is probably their biggest argument, that he was accepting whatever mess might be there, and he was going to be the fireman to kind of knock down the fire.
Right.
And the fireman doesn't say, well, I'll only knock down the fire if the fire is at a certain intensity.
Correct.
Say, I'm here to save the world. And, I was listening today, just to contrast for a second where I'm coming from. He was very sober in the Tesla earnings call.
Yes.
He's on audio today.
Yes.
It was for a couple of hours ago. Basically reporting good results for Tesla and lots of forward statements, but very sober about, look, the world is in trouble. We've got to figure out a solution for this energy issue. These lithium batteries really make the difference. We can scale it up, but we need continuous innovation, and we're trying to save the planet from burning down and got to get rid of fossil fuels. It's the same theme. And we're talking now about this whole separate fact that he's in litigation in a context that's in Delaware on a very short, tight schedule that the judge has just yesterday or the day before issued an order on.
Yesterday, yeah.
Yeah, quite quite an aggressive schedule for a major piece of litigation with big law firms on each side. So I wanted to just ask, and hopefully we can both just banter a little bit around just the top 10 questions that anyone on the street says, oh, you're a lawyer. What do you think of this? What do you think of that? And of course, it's the same type of questions, and they're very basic. Like, why is it that a company in California and a defendant in Texas, which is where he now is resident and has his companies, and including these entities as their principal place of business, why are we even in Delaware? Like, a lot of people don't understand how the legal system works, and they scratch their heads saying, how does a Delaware judge end up even, or how's the state of Delaware, which is where Biden, I think, was a senator, right, before he became president. Right. Like, how does a courthouse in Wilmington, Delaware, become the place of action for this mega litigation?
Well, first of all, both corporations, plaintiff and defendant, are Delaware corporations. They're incorporated in Delaware. The agreement stipulates that the Delaware Court of Chancery is the first choice for where to go. Right. So the parties have the right to stipulate to jurisdiction.
Right. They sort of like decided to pick their poison, and they're not poison, but their neutrality. And the Delaware courts have like an exceptional reputation for neutrality and corporate knowledge and speed. And speed, because like my answer to people that ask this question is, well, if this case were filed in California, get in line, you probably wouldn't see a trial date for 3 years. And even if it's expedited, it probably wouldn't be even 18 months.
Correct.
And if it was filed in Santa Clara County, where the principal offices used to be in Palo Alto, not too long ago, he shifted location.
To Texas.
Yeah, to Texas within the last year or so.
Right.
It would be a lengthy slog. And there would be a lot of question about, can the California courts really even handle such a complex corporate case under Delaware law, which is what was stipulated. And I think the same is true in Texas. I don't want to speak that Texas is somehow below standards, but they're not necessarily considered to be the corporate gurus of the world the way Delaware is, right?
No. I think the agreements, the corporate entities are all Delaware entities. And that's sort of the end of it, because this is not about a breach of a territorial promise. It's the fundamental agreement.
Right, between two Delaware corporations that stipulate the Delaware law. The New York law firms on each side, they're both in Manhattan. But they still don't use New York law, and they don't use the New York courts. They prefer this idea that Delaware is the place that everyone believes of all 50 states, without exception, have the best judicial minds for corporate law. And so it's like you've selected your decision maker. And that decision maker essentially has a lot of, what's the right word, hegemony. They have a lot of gravitas. They're recognized. And then the second question I get often, I'll just reel them out, is, why a state chancery or equity court there and not some regular court? Why is it that court in particular?
Well, I'm puzzled by the fact that Twitter is seeking specific performance. And in order to have specific performance, you need an equity court. Right. So that answers that question. But why do they want specific performance? And why are they entitled to specific performance, even if the agreement says so?
Right. I mean, specific performance is itself a very unique remedy. In law school many decades ago for both of us, the very first thing you learn is it has to really be a situation where it's a unique piece of property or a unique
money damages won't do.
Yeah, money damages cannot possibly do. And you would say, look, if at the end of the day they're trying to get $54 billion of $44 billion of consideration, I think it's what, a $54 a share price.
Correct.
The judge's orders, just pay the $44 billion. Thank you very much. I guess if you don't want the company, you don't have to have it, but it's up to you. You can take the company, you can leave it. If you want to leave it, then the shareholders will get it as a bonus.
Right.
And that's a judgment call. We don't need to micromanage this thing, right?
That is my view of it, and I do not see why specific performance is even on the table, even though the agreement has a couple of sections saying we're entitled to specific performance. I don't think that recital by itself, without more explanation or more support, creates the right to specific performance.
Yeah, you can't impose on a court what's fundamentally an equitable consideration, right?
Correct.
Courts have independent judgment and independent power and independent discretion. So
Right.
even though you can say everyone waives an argument about damages being adequate and all that jazz, courts can say, you're wrong.
Right.
This case in particular is one where, and then fill in the blank on whatever they decide. But in terms of the remedy of specific performance, we see that a lot more often in real estate deals where the view is unique property, unique longitude, unique latitude, even if it's a tract home that looks identical.
No, every piece of real property is theoretically unique. Right. If I promise to buy a violin, if I promise to buy your car, those are unique items. Car might not support a specific performance claim, but your Stradivarius would, and any piece of real property would. But here, if he handed them $44 million, I don't think that Twitter has anything more to seek in the case.
Right. And they would get the bonus of, if you want to keep your company, you can have that as well. And
if you want it.
Now, maybe it would be viewed as a wacky sort of windfall, in a sense that the bargain is, here's all the stock and you pay the money, and where you want to take it private, you can do that. If you want to keep it public, you can do that. It's basically your horse and buggy. It's your piece of real estate. You have to pay the real estate taxes, I guess, if you look at it from a real property point of view.
Right.
I mean, I don't think Twitter actually owns any real property, so it's really just the intangible. It is a very intangible business. They have lots of employees, some of whom I guess still go to the office or now report back to the office in San Francisco. Their principal offices are in San Francisco, although I heard they put a lot of the space up for sublet because most people actually still work from home.
Okay.
So it's an interesting situation in terms of keeping the workforce, which is a big stakeholder in this, right?
Yep.
They want their jobs. But how does the court manage specific performance if somebody says, I'm not doing it? Like, how do you get them to do it?
I think you can hold them in contempt and put them in jail. But I don't see...
Right? Ultimately, that's the ultimate sanction.
That's the ultimate thing, but I don't see that happening here. I really don't see it happening here. The $44 million, if Musk just wrote them a check for $44 million and said, either give me the stock or don't give me the stock, what I really think the damages are from a contractual point of view is the $44 million minus the reduced value of Twitter shares.
Okay. So the shares have rebounded a little bit. They were at a low, right? They rebounded a bit. But if they got an infusion of substantial cash, because you're sort of hinting at the judge has set up a negotiating problem now as well in parallel, or a mediation problem, which is your forte and my forte as well, which is, look, if you look at the best alternative to the negotiated outcome, what's sometimes called the BATNA, the BATNA, you may not like having to own a company where all the individual employees hate you and they all quit and you've got no business left. You have to figure out a way to actually get new people in, which is a very, very substantial cost. So whatever you messed up here by not making this a smooth transition, that's your mess to deal with, which can be a much more expensive outcome for him when all is said and done, right?
Yes, I think so. And, what did he really have? What was his real ambition to own Twitter? What's the point?
Well, it's almost like it's the loudest amplifier currently on the
megaphone.
It's a megaphone, and it seems to outpace Facebook and Google and Apple and all the others combined.
Okay.
Because there's a certain, I don't know, literati, there's a certain set of news organizations, there's a certain set of famous people and influencers. There's a lot of garbage as well, I think, unfortunately, like the internet itself. There's a lot of junk. And I personally think it's higher than 5%, but I don't doubt that the evidence is going to be conflicting on just how much higher it is. Their SEC documents report that it's under 5%, and the merger agreement says that the SEC documents are accurate, but it also says those are estimates. So
let's get into that for a minute. There are about 500 million Twitter users, I understand.
Okay.
And Twitter does not charge a subscription fee.
Correct.
So all its revenue comes from advertising.
Right.
Isn't that true? So suppose it has 10% bots. Suppose it has 40% bots. It would have to go to the point that the advertisers say, this isn't worth paying the money to advertise here. If it's anything less than that, it makes no difference to their revenue and therefore no difference to Musk.
Right. The counter argument is something like it's a fire that is at a certain controllable level, and I'm willing to be the firefighter at the 5% level. But if it's 10, 15, 20% level, then the advertisers eventually will start to understand that the fire is raging and is going to destroy the eventual dollars that they invest. And that's not a fair deal, because I could clean up a certain fire, but I can't really deal with a fire that's going to wipe out that revenue maybe in a few quarters from now. It's like a little bit of what's the future for the world? Is the earth on fire? We've had some of the hottest days throughout the entire world, including in Europe, that are just knocking the socks off of people in terms of the heat level.
Yeah, but let's focus on the firefighter. First of all, one of Musk's main complaints is you've hired a few people to check 100 accounts a month or whatever that number was.
Right.
That's not the way you need to do it. You need to have an artificial intelligence system that goes over your 5 billion accounts and identifies the potential bots and pursues those.
Right.
And I'm smart enough to write you an artificial intelligence machine like that. Therefore, the cost of putting out the fire really doesn't increase if the number goes up higher.
Oh, that's an interesting counter to my counter, which is fire. I've got firefighting equipment that is out of this world, and I'm saving the world on energy as well from Tesla and AI. And I'm still going to save the megaphone, which I think is important for the world. Like, I think he's at a very high level of abstraction. I mean, I think if anything happens in this case where his testimony goes to the level of abstraction that he states on his earnings calls, he's at the level of, I'm saving the world, like the equivalent of Jesus Christ coming back to earth to save a world. I'm almost like from another planet. You guys don't know this. I'm actually not just from South Africa, but I'm actually from Mars. I want to get back to Mars. I'm here to save your planet. Part of saving your planet includes the energy problem. Part of saving your planet includes the First Amendment problem. And there's probably a third, fourth, fifth, and sixth, because, you know, SpaceX and all this other stuff, the Boring Company, they're all part of this mega intelligence that he's trying to bring to big problems. If he's at that level in front of this judge, he's going to say, you got cold feet for reasons having nothing to do with the way you originally looked at this.
Right.
You got cold feet for some other reasons that you're not expressing, and that's unfair to Twitter. And you didn't get an option contract here. You got a real contract with a real agreement that represented a real agreement. And I'm going to compel performance. And your point is, well, or you're going to pay the money and they're going to get to keep the company to boot, almost like the equivalent of pick your poison. If you really don't want the company, cut them a check. And, you know, if they get a windfall out of it, they get a windfall out of it. They may need that money to deal with the morale issues, right?
Perhaps. I again, if I were the judge, I'd say, well, when you came in here, the price per share was $10. Because of this, it's gone down to $3. So I'm going to have you pay the damages of $7 a share.
Right.
And they keep the company.
Right. And that becomes part of the alternative negotiation, alternative
Correct.
mediation, alternative
Correct.
business
Correct.
planning. And at a board level, it's a very difficult board discussion because most boards don't like litigation. They find it too uncertain.
Right.
They don't know whether the appeal of the case, whatever she decides, may go the wrong way. They don't
Right.
like all the legal fees that are involved. They
Right.
don't like all the publicity that could go one way or the other, particularly if the bot situation, and I want to focus on that again, does he have some potential separate unclean hands defense to equitable relief that's simply based on there was a certain level of deception? It may not have been fraud. It may not have been affirmative misrepresentation, but there was some certain level where disclosure, true disclosure, would have been a much more complete picture. And that represents what in California we call unclean hands. I'm not sure what Delaware does, but the traditional doctrine of unclean hands would support an equitable defense, right?
Well, who has the unclean hands here? Musk or Twitter?
Well, I'm saying really Twitter, Musk would assert that unclean hands is his principal defense to the equitable relief, and he'll pay the $1 billion with a B in termination fees because specific performance is not available if there's a sufficient showing of unclean hands, would be his argument, right?
By the way, why is the $1 billion not in the agreement? Why is it in the statement?
I don't know that. I don't get that either because I've searched for it too. And I would assume there's a definition of termination fee that we're just not finding.
No, I've looked for it 3 times.
It's $1 billion on each side. If each side disengages for whatever legitimate reasons or quasi-legitimate reasons, they may have to pay $1 billion. They effectively puts that kind of skin in the game. But, you know, that's really like 2% of the actual dollar consideration. It's not a huge number.
No, but
dollars here.
If I were the lawyer, I would have had Musk put the $1 billion, give the $1 billion to Twitter at the beginning as an option.
Well,
so you now have a 4-month option.
Yeah, I wonder what would have happened though in that context, whether they would have said, there's too much uncertainty from taking that money. If it doesn't close, our stock price may zigzag. Like there's a fiduciary issue for the board about what are the trade-offs about taking that money, right?
Maybe.
Let's say that's just pure profit after all the legal fees. Maybe you don't pass that kind of gift horse in the mouth because there's no real money that is actually in anyone's account yet. But the Delaware court has control over his Tesla shares because Tesla is also a Delaware corporation.
Correct.
So she could actually move some of those shares. If he didn't pay the money, she could actually order title transfer of those shares. And it seems to me that that's the ultimate maybe power before contempt would happen. Well, you have an alternative. I'll just slice off a bunch of your Tesla shares and they'll get those shares and be a major, Twitter shareholders will become a major shareholder of Tesla and with your shares, not company shares, what you own. Right. So why is there no jury? You know this equitable stuff inside out.
Equity cases don't have juries. You know,
why is that? Like, why is the questions of fact not separately decided by a jury? Because I know federal judges get into this question of disputed issues of fact get decided by juries, but equitable decisions and decisions associated with equity get decided by the court. But here we have almost like expedited trial, no jury, very limited schedule, very accelerated schedule. Seems like certain due process is different.
I think the court has the authority to segregate issue, to have the jury address questions of fact and then make equitable decisions. But the judge is not required to do that. So I think that's the rule. And she's just an equity court, so she doesn't have a jury anyway.
Right. So to me, a jury would bog this down totally, because I can't imagine getting a jury to understand any of these concepts in 5 days. And I can't imagine a jury feeling comfortable with what might be called the higher order decision-making about the certainty of Delaware law. Like, you could almost argue you want a judge. Now, maybe it needs to be more than one judge. I mean, she has a lot of power as one judge, obviously. Maybe it should be 3 judges, but it's clearly, an important case from a financial point of view, right?
Well, the fact issues which need to be resolved.
Mm-hmm.
The first fact issue is the number of bots wrong, and is it materially wrong?
Right.
That's difficult for a jury. That's going to be a battle of experts, and there's no way for the court to really count. Counting is not available.
Right.
So it's not really that to me is not a jury issue. And more important for the judges, does it matter? I think, equitably speaking, it doesn't matter.
That was the argument
Even if
that
it
was made. That was the argument that was made on the expedited trial, which is this bot issue is a sideshow. He weighed the diligence on the bots. So he was the fireman willing to come in with the big fire hose, regardless of how big the fire was.
Right.
Period. Full stop.
Right. Right. Well, he waived the due diligence. And also, Judge, if you think about it, what real difference would it make if we knew that there was more than 5% bots? And is that 5% every month? Is it the same 5%? What is it? It's just not clear how this impacts Twitter's value. And the other thing is, the bigger these networks get, the more bots they're likely to attract.
Well, even now, you might argue there's a certain dynamic aspect to this where somebody could be paying people overseas to generate lots of bots so that some measurement issues that happen today, like the word is out on the street, hey, load this thing up with bots because we want Twitter to sync, or we want Musk to win, or vice versa. Stop issuing the bots. We want Musk to sync. We want Twitter to win. Like, there's all sorts of gaming potential that's here.
But go back to days pre the lawsuit. Why would somebody have a bot on Twitter? What's the benefit? What's the point?
Well, the view is that they can influence behavior, including buying decision behavior. This is stuff that even Amazon has filed a lawsuit yesterday or the day before, where they thought the reviews were being automated by bots. And so they're trying to drive sales behavior through bots that are not real votes by people about how good a product is. And Amazon has decided its brand is too important to allow that to occur. So to file the case in I think the federal court in district court in Seattle and Washington.
I didn't read about that. Did you read that Amazon stock took a plunge?
No, I mean, yesterday or today?
Yeah, yesterday. Yeah.
I don't know if that's associated with that fact, but conceptually, they have a problem. This people game these systems, and they game them in ways that creates a disconnect from reality. And obviously, in the bigger picture, Facebook was gamed by bot-like behavior dealing with the election. And you could argue Twitter was probably gamed as well, and it might be gamed again. And it takes a lot of resource, a lot of technical resource to try to fight the kind of activity that occurs, because it's automated, and it's automated at a high level. And a lot of the automation is overseas and not easily controlled and not easily dealt with by litigation. But going back to this whole question of damages and why don't they suffice, when usually most court cases are about money. And most of the time it's about the amount of money. And most of the time it's about, what's the specific reasonable range of the amount of money. I mean, you have a pretty strong view about this, that's probably what presumption should even apply in this case, right?
Yes. And what else would Twitter get out of this deal once the $44 billion was paid? Nothing. They would have no shares left, and they would have $44 billion in the bank.
Well, wouldn't the shareholders get that money? The way it would work is the shareholders. So there's a whole regime of tax issues that kind of complicate this at a certain level. Now, maybe you could say, well, that can be factored into the money, but the money usually doesn't go to the company. The money goes to a third-party escrow who then figures out what shares each person has.
Right.
And cash is delivered in exchange for shares. Essentially, they're selling, all the shareholders are voting, and if it's over a certain magical number, typically 90%, with maybe if there's 10% dissenting, they can go through a different valuation process. But typically there's a approval by a supermajority, usually not just 51%, but I think in some cases it can be as low as 51%. And then that deal is done on the democracy of a majority of the shareholders want to sell out the company to a private buyer. And if you want to dissent, you can dissent and you can go through a valuation process. But this price was pretty high compared to the market price of the company.
It was above market. And I thought it was the board that approved it, not the actual shareholder vote.
Well, then the shareholders have to back the board with their proxy. They have to ratify and say, we're with you. Like if 49% went the other way, they wouldn't be able to close the deal.
So they did that. They submitted it to the shareholders and got approval.
Well, they're in the process of doing that. They actually haven't yet gotten that.
Oh, I thought they had.
No, they were in parallel. See, the closing is supposed to happen in October, but because he is repudiated or reneged or properly terminated, depending on how you want to view this, he's never demanded that they pay him the $1 billion. That's the one thing he hasn't done up to this point. Now, maybe we'll see that kind of counterclaim here, which would be interesting if he takes the aggressive view that you misled me and I want my $1 billion termination fee. But they're actually in the process of circulating the proxy materials like this deal is going to close and we need shareholder votes. Now, he's one of the shareholders. I think he has bought.
He's a major shareholder.
Yeah, he's a major shareholder. And at one point, I think he did suggest he was going to become a board member. And I wanted to ask you about this because you wrote the treatise on fiduciary duty. What if he had actually become a board member? Ultimately, he decided not to. But what if he had become a board member and then he signed this agreement? Would there be yet a different set of principles that would apply to him as fiduciary signing an agreement to basically take private the rest of the company? Would that change?
Well, I believe so. He has fiduciary duties to the shareholders, obviously. I want to back up for a minute. If the shareholders have not ratified it yet, then there is no specific performance available.
It's all being done in this parallel path.
That can't work. That can't work.
Well, that's what's happening. I can tell you that's where Wachtell Lipton, that firm, kind of the expert, less than 300 lawyers, the last count I saw. It's not a huge mega firm, but they have a huge mega Delaware M&A type practice, and they're one of the most profitable firms in the world, certainly in the United States. I mean, their profits are typically 3 to 5x per partner higher than the average partner profits at most big law firms. And they're not a big law in terms of most big law firms are like over 2,000 lawyers. They're like 300 lawyers, but they have a lot of expertise and they do their fee arrangements in kind of a value proposition way that they're very proud of. I can't imagine what that fee agreement looks like. It must have been a major negotiation to get them on board. And they certainly came on board with kind of a firestorm of filings, of which they've won certainly the first inning or the first round. Motion to expedite.
When is Musk's answer due?
So I think it's like federal practice, 20 days.
20 days.
So we should see it.
Next week.
Yeah, we should see it next week. And then we'll see whether there's a counterclaim of some type and whether there's some sort of, hey, they actually owe us $1 billion, and or whether there's some type of motion that says this is all moot or not ripe until we see the shareholders actually vote, because Musk is not going to vote for this, and Musk maybe can persuade others to not vote. But most of the press is so far that I've seen is so in favor of specific performance.
Right.
It's hard to believe that any organization that makes recommendations to institutional investors won't say, back this deal, take the cash, move on. This is not a company that can do any better than what you can get out of going forward with this deal. But yeah, that's all in parallel process. That has not happened yet. It's another wrinkle in this story, isn't it?
Yes, it is. And by the way, that also puts a roadblock on the contract claim. So until that is all done, this may be not ripe for adjudication.
So whether we'll see that kind of motion and then how she decides it, she seems to be of the view that presumptively there'll be a vote in favor, presumptively there'll be a trial in October, presumptively there'll be a discovery process that gets done within the next 3 months. And I wanted to talk about that. Like, what is actually that going to be about? What do you see as the actual issue that gets some discoverable traction here?
Well, I'm sure they're going to call experts on the bot counts.
Right.
And then there was argument about whether they conducted business as usual or changed salaries in some way that was not permitted by the agreement. And that'll be a matter for discovery.
Okay.
I don't know about 50 witnesses, but you can quickly ramp them up.
I mean, to me, it's like if they take 52 depositions at the typical 7 or 8 hours on the record, usually 7 hours on the record, 8 hours total with a lunch break, that's 350 plus hours of video recordings. You can't show 350 hours of video recordings in a five-day trial.
Correct.
5-day trial at 7 hours a day is a 35-hour trial. Even 8 hours a day, assuming she pushes herself, is a 40-hour trial. You have to imagine this being like 60 minutes, where there's lots of video that gets cut into snippets of points, right?
She's going to make rulings on specific issues that will eliminate a lot of the factual disputes, in my opinion.
Right. I mean, if she's decided on a 5-day trial, she must have done that from some experience, because she has experience and she has done specific performance in a hedge fund case that involved KKR, 2 hedge funds. Yeah. I mean, and there is a published decision, and there is a 150-page or so ruling by her that's very detailed. So she's going to be bringing all that knowledge to bear. In fact, she must have gotten the appointment from the various judges of that court saying, look, you're the expert in this area of specific performance. You're the only one that's granted specific performance recently in a recent published decision. You should take this case. I can't imagine that this was a random selection, but maybe it was. Maybe it was randomly assigned to her. I haven't seen any reporting on how she ended up getting the case, but they've got the game plan there from that case. And to some degree, you can argue that a lot of her judicial thinking is in that opinion. So you've got a lot of material to work with if you're lawyers on each side. So I want to get back to this whole question of what actually happens in this 5-day, let's call it 40-hour trial. 20 hours per side, if she's fairly allocating time on some view that we should have fairness each way.
Well, I don't know. There may not even need to be a trial, because there may not be any real disputed issues of fact that are relevant to the outcome. I know there are
some summary judgment motions get filed in September or early October before.
I think so.
She decides the case.
I think so. Or she could come to trial and say, I want briefs on, is there any specific performance here? And if not, what are the money damages? That's it. And is there a breach? Is there a breach is the biggest issue. And I'd like to see Musk's response to see what he thinks about breach.
I mean, at some level, you could argue if she wanted to kick the can down the road, which she didn't do, she could say, look, I don't know if there's going to be a counterclaim. I don't know what the answer is yet. I don't know what the defenses are yet. I think I know what's coming, but I don't know for sure because that's up to the defense strategy. So how can I decide whether it's 40 hours or 400 hours of trial time? And how can I decide whether it's, October or next year? So let's kick the can until we see those pleadings. But she didn't do that.
But of course, she could do that after next week.
Right. She could say, now that I see this, maybe I'm a little hasty. But, I think that the judicial temperament is one where you don't want to vacillate if you're a judge. You want to be like, I've got my hand on the rudder. The wind is strong, but we're going to sail this boat to its port. And, win, lose, or draw, it'll be decided on the merits of the case. And if we have to bifurcate out certain things, we'll bifurcate them out. But we'll get the major issues that are driving the BATNA, that are driving whether you guys should negotiate or not. Because most judges, I think, frankly, do want to see parties negotiate and then voluntarily close.
Yes.
The strong arm of the law is really more about the war that doesn't have to be fought as opposed to the one that does get fought. It's like most wars are won on sort of the setup as opposed to in the actual heat of battle. Now, sometimes that doesn't work in war or in litigation, and you have to have a trial and you have to have an appeal and you have to have a lot of other activities. And she seems to be saying that's what the setup is here. And so I'm going to help you guys set it up. And then from there, we're going to go from there. So to me, there's a lot going on in this case, Raphael, and we could spend a lot more time on this.
I think we should wait at least a week to see what's coming down.
Yeah, I mean,
before addressing it further.
Yeah, I mean, to me, this basic 101 about why Delaware, why not Texas, why not California, I think it's a good podcast topic because lots of people scratch their head and say, I don't even understand. Does everyone now have to fly from Texas or California to Delaware? And the answer is yes. I mean, unless she actually does something extremely novel, which is apparently she announced that she has Omicron and tested positive. So what was supposed to be an actual in-person hearing into a Zoom call.
Yes. And by the way, who has to travel from Texas?
Well, Musk is in Texas. He lives in Texas now.
All right. So Musk will travel. So what?
Oh, I think it's Musk.
Not a lot of people.
No, I think Musk had a whole big deal team in Texas. Like Musk has advisors, and the Musk advisors that were involved along the way are a big contingent in the Musk family office. I mean, Musk is the richest man in the world, I think, at the moment. Now, maybe Tesla stock is zigzagging, I don't know. But generally speaking, Musk has a family office. It has a philanthropic aspect to it. It's got all these other companies that he's in. I mean, essentially, he's got this save the world mentality that we hear often. And the family office is part of that entire enterprise, the Musk family enterprise. And so it's a much bigger operation. And I imagine some number of those witnesses are not lawyers. There will be no privilege issues, and they will have emails, and they will have texts, I'm sure, and probably Slack channels and other ways to communicate that will tell more of the story of what exactly happened here and when did it happen.
And when did Musk, what happened to impact Musk's decision-making?
Right. And what was the, causation, and is this pretextual? Is this just made up as a way to sort of create a tribal issue, if there is one? Or is it like he's always been concerned and he was somehow really in need of more data? I mean, of course, it's all suspicious because the due diligence was waived, apparently, and no one has suggested otherwise. So it's such an interesting story. And I can't even recall a case as big in the context of a purchase of a business as important to what might be called the Silicon Valley ethos of this First Amendment amplifier, which Twitter is. And I have to believe that other billionaires like Zuckerberg and Gates and, a host of others are looking at this case and saying, wow, this is like an amazing story here. And is this really the way this is going to play out? And is it really going to be a court that decides this, or will calmer minds prevail? And then what will that outcome be in dollars and cents? So just such an interesting story wrapped up in this. And of course, Tesla stock was pledged for a lot of the financing. So it could zigzag some of Tesla, particularly if it has to be sold.
Right.
Fire sale deal later this year, if that becomes the outcome. So it's such an interesting thing to keep track of. And I hope you'll come back on and talk about it, because
let's keep watching it and seeing how it develops.
It's such an interesting story. Thank you, Raphael, for giving some of your time today on this.
Be well. Nice to see you.
Really insightful. You're really such a great person to talk to about these complex issues, because you help provide illumination that a lot of people...
Let's just say that I would advise Musk on a different agreement.
Right, of course.
Not the one he signed.
Right.
Anyway, let's see how it develops.
All right. Thank you for your time, Raphael. Talk to you later. Bye-bye.
Bye.
Take care. Good.
Tune in next time on The Valley Current.